Good morning, and thanks for joining us here on Condo Solutions every Monday from 9 to 10 o'clock. We talk about issues that you may have at your condo or homeowners association, some of the problems that come up, some of the questions that come up, to some of the things that you may want to ask about or wonder about. Maybe you're new to condos in Florida or homeowners associations in Florida and not familiar with the restrictions or the rules and regulations. And you're just kind of curious, can they do that, or why do they do that, or what's the reason for that? And actually, the better people understand what the restrictions are, the better appreciation I think you have for your board members. Sometimes board members take a lot of flack, and so do property managers, board members and property managers. And the reason is that, a lot of times there's not an understanding sometimes of what restrictions or limitations that those board members or that those property managers are under. So that's one of the things that we try to educate and talk about on the show. It is a community service program, so you can call in at 220-9788, 220-WSTU, and ask your question. We don't deal with real estate in terms of the value of your real estate. We do talk about rentals sometimes, just from the standpoint of the impact on the association and what the restrictions can be there. But we're not a real estate show, so we're not selling anything. We're just trying to help. So again, 220-9788 is the number in the studio. My name is Mark Breckbill. I'm a local CPA and a community association manager, along with Peter Mullengarden. Peter's our attorney, and he has been practicing in this area of the law. He doesn't do this just occasionally. This is what he has been doing for most of his adult life, and has quite a bit of experience in this area, and has dealt with a lot of the problems. So Peter is our expert on the panel. Good morning, Peter.
Good morning, Mark.
Good morning. And then the only other thing, like I said, we always give this warning. There's really two warnings, but one just goes unspoken, and that is don't ever believe anything Mark says. But pretty much that beyond that general caveat, we do the best we can with your question. We don't need to know your association. We prefer we don't have it, because other listeners sometimes think it doesn't apply to them then. But we don't really need it because we don't have your documents. So, so from a practical standpoint, we have to keep our answers somewhat general, based on what you tell us your documents say, and based on what the laws are. And as many of our listeners know, the documents can affect and override what the laws are, depending upon if the documents are more restrictive or not. So it is difficult sometimes to give you a hard and fast answer. So if you need that, you need to contact Peter directly, and he'll be happy to sit down with you and come up with something for your specific situation and help your association. So generally, just have that as a caution. Otherwise, we'll do what we can and give you the best answer we can. And we do tend to talk a little bit broader around the problem than just your question, because there may be some listeners that have the similar fact pattern, but not the same fact pattern. And so they may, some of that discussion may help them. We have our first call this morning. Stanley, go ahead.
Good morning, gentlemen.
Morning.
Thank you for taking
Good morning.
call.
Sure.
Yes. As a member of the Condo Association, I received the following email message from the association, and it's addressed to all. It states, all events sponsored by the rec committee in the association and private parties will restrict the use of alcoholic beverages. In other words, no alcoholic beverages, period, including no bring your own booze. Our attorney has advised this course of action. This message also appeared on our website under announcements. Now, this has raised many questions within the minds of all of the membership of the associations. We're trying to find out what has happened. Can you advise us what steps to take?
You want to go on that one, Peter?
What steps to take to try to rescind this rule, or find out why they did it, or
understand what happened? Why?
Well, for one thing, as far as the total ban, I guess I'll address that in a second. In Florida, you can't have the sale of alcohol without having proper permits and licenses and things like that. And that includes any type of system where, obviously, if you're buying, directly per drink, or even if you're, any time where you're paying any kind of compensation, whether it's an entry fee or, charge, and they're serving alcohol, so all that stuff is a sale of alcohol. But as far as, BYOB and bringing your own, I'm just guessing here, that the association is concerned, I guess, potentially with liability in terms of people, becoming inebriated and maybe driving afterwards, or doing whatever and getting injured or injuring someone else. Rules and regulations, with respect to the common area, common elements must be reasonable, and reasonable must be rationally related to the promotion of the health, safety, and welfare of the owners or the property. So again, I guess I'm presuming here that it was determined that serving of alcohol, consumption of alcohol on the premises, whether there's consideration or not, I'm assuming that there was a feeling that the association was being exposed to potential liability that it didn't want to be exposed to, and they felt it was the best interest not to have alcohol. Now, you can argue the rule is unreasonable, but likely it would, I can't swear to it, but I think if it was challenged, it probably would be held reasonable as long as the board had a rational basis for this rule.
Peter, my point is that you said the right words. You said you were guessing, and that's what we're doing. We're guessing.
Yeah, and I'll tell you, Stan, I think that here's what I think that the answer is.
I mean, Stanley, hang on, Mark. Let me ask one more question. Did they adopt this rule at an open board meeting?
No, it was not. It was sent out on a Friday afternoon.
Well, you have one potential challenge then, that the rules should have been adopted at an open board meeting, where the membership would have had the opportunity to question. Now, it doesn't mean the board had to answer those questions, okay, or at least comment on the rule. So it may be you have at least a procedural thing to say this rule was not adopted properly because it wasn't adopted at an open board meeting. Now, it doesn't mean they can't ratify it at another board meeting, but procedurally it should have been adopted at an open board meeting, at which time at least you would have had the opportunity to comment on it. And again, you can ask the board questions. Do they have to answer those questions? No. They can sit there kind of stone-faced and decide not to. There's no legal requirement, but it does. But politically, it makes them look a little bit odd if they just don't answer any questions. So that's a procedural, issue.
Okay.
Mark, I'm sorry. Go ahead. I didn't mean to interrupt you.
Just correctly, that essentially we can't question why this was done by the board.
No, you can question.
No explanation.
Stanley, this is a homeowner association, right?
No, it's a condominium.
Oh, I'm sorry, it's a condominium. Well, then what you could do is you could send a certified mail inquiry to the board. You send it by certified mail, and you basically say in your inquiry, what is the rationale, what is the reason for this rule? Under the Florida Condominium Act, when they receive an inquiry by certified mail, they must provide you with a substantive written response within a certain amount of time. Now, how substantive will they be? I don't know. But that is a way to force them to respond.
Understood.
Stanley, here's what the issue is. I mean, here's what it really is. And that is that Florida in particular has gotten extremely litigious relative to nonprofits and homeowners associations and others. It used to be that an attorney wasn't going to go sue a condo association or a homeowners association for something like this because it wasn't worth it. They didn't have coverage, and it just wasn't worth it. But more and more, the associations have coverage, not necessarily for alcohol, but they have coverage for liability on premises and for things that happen relative to that. Um, these parties, there's nobody there. There's not a bartender or somebody typically who is monitoring how much people are drinking, whether they're bringing their own booze or, there's booze available from friends or whatever. And these guys, then people go out on the road afterwards and somebody gets hit, and the attorneys look for the people with the deep pockets. And initially the condo association has deep pockets. So they go after the condo association. The homeowner may not, the person that got hit may not. But anyway, that's what's happening. I mean, I'm seeing it happening in nonprofits. I'm seeing it happening in a lot of areas where they're just the attorney is just giving really practical advice based on what's happening in society right now here in Florida in particular, and is saying, look, you guys are running a risk. Now, there's two things that you don't change in the state of Florida in a condo association. You don't raise the dues, you don't cut off the booze. That's pretty much the rules. You get unelected if you're a director and you do either one of those two things.
Well, you're hitting on this very sharp point. You're absolutely correct.
Yeah. So my suggestion would be, as Peter has said, you can challenge this because it wasn't done correctly for discussion purposes. I mean, it may be that everybody as a community, you guys may decide there's just too much risk there. And on events, you're going to go to someplace else where there's, not on premise. You're going to go someplace else to do some of the stuff. But people don't want to. They want to have these things at their own home. And
there is host liquor liability insurance.
Right.
I mean, it's something you have to look into. And there are some protections, generally speaking. There are some statutes. I mean, there are statutes that apply to bars and restaurants where, generally speaking, they're not liable for someone, drinking too much unless, you knew or should have known the person had, reached their limit, or was susceptible, because of their physical condition, to alcohol. I'm not saying you should rely on that necessarily, but there are some statutory protections there. There are some insurance policies, but it sounds like Mark is right, which is what I was saying, is that there's a fear of potential liability, and rather than having to deal with that, they just went to the route of we're just not going to serve any or allow the consumption.
Stanley, I'll make a suggestion because I do this when the subject comes up. We deal with this problem a lot from the standpoint of a lot of associations have committees that they've set up to have activities and that type of thing. And there's this weird relationship between these committees and the board. Sometimes there's a board member who specifically is representing that committee. Sometimes the committee just kind of hangs out there. A lot of times it's using the association's tax ID number. So it's dragging the association into it, even though it may not realize it, because it doesn't have a separate bank account. It doesn't have a separate, situation set up for it. It doesn't have separate insurance and all those kind of things. So I've over the last few years, because of this litigation and things, I'm more of an advocate of being a little bit more proactive and taking that entertainment activity and kind of isolating it into an LLC that's owned by the association. That kind of can help. I think it helps limit that liability. You can also get a separate tax ID number for it. You can insure it, but you're not a separate entity. You don't have to file a tax return for it. It doesn't have to have a separate board necessarily. It just has to have a separate set of books. So whoever's keeping track of these activities, they just need to keep track of them and show them on that company's books, so to speak. But I think that's a way that you can do this. These liabilities are ignored for tax purposes, but for legal purposes, these limited liability companies are a legal shelter to some degree, and they work really well in the commercial businesses. We've been doing this for a while, and I think in the homeowners and condo area, it's a nice compromise on this issue. Instead of going all the way out, let's just isolate the liability to something that doesn't have any assets. That's probably I think the better way
Yeah,
to
but
go.
Mark, I mean, but if they're consuming the alcohol on the property and its common element, how are you avoiding this liability?
Well, are you just brought up something, Peter? When you say the common element, let's assume that I want to go up and sit on the patio and have a beer and just look at the ocean. Am I prohibited from doing that?
Well, I don't know what the rule says. I mean, the rule says you can't drink in your own unit.
No,
is that what you're saying?
No rules. The notice says all events sponsored by the rep committee and private parties. It doesn't say anything about personal consumption. But my point being, I'm not in jeopardy with personal consumption on the company property or the.
Well, that depends. That depends how the rule is worded exactly. I mean, if the rule says, and actually there's an old case that actually said that this kind of rule was enforceable. It was one of the Hidden Harbor cases. But if I recall, if they pass a rule banning the consumption of alcohol on the common elements, yeah, then that would mean that you could not bring your own beer, your own whatever alcohol, and drink it on the pool deck or in a patio next to the clubhouse or anything. That would be what I mean. That's what that means. I mean, assuming that's what the rule says.
Well, let me ask you. You are referring to rule, and I'm talking about this memo, which is an email to all. It doesn't say rule. It doesn't indicate anything like that.
Well, the only way to do it would be either through. The only way to, and your phone's a little breaking up for me, but the only way to do it would be either through an amendment to the Declaration of Condominium or through a rule. You can't just. I don't think they can just do this by a policy, okay? Because this is a rule restricting the use of the property, so it would have to either be an amendment to your declaration, which sounds like they did not do. It sounds like what they're trying to do or attempted to do was pass a rule or amend your rules regarding the use of the common elements.
Okay,
Yeah.
I got it.
And Peter, to address your question, how I would handle that situation on the common element is that every time there's an activity, recreational committee activity, it would enter into an agreement with a lease agreement with or a use agreement with the association itself. It would just be a contractual thing that would make it liable for any activity on the premises under that activity, and therefore, the association is has
leasing the property to the LLC for the activity.
Yeah, not really. Yes, like a use agreement or a lease agreement. Yeah, some sort of a specific use provision there that then isolates that liability. The agreement says that you are responsible for all legal, all liability, all having insurance covering yourself and all that kind of stuff. But anyway, just to try to, again, it's not perfect, but I'm trying to just segregate the day-to-day activities where they could get to the homeowner. Let's at least try to keep it, try to separate it from the homeowner a little bit. But, it's, but it is, Stanley, I don't see how, I think to some degree this is an overreaction on the part of some people. I suspect what happened is that the law firm that's involved may have had a big case where that or there may have been one that just got settled that cost an association a bunch of money, and they just feel it's their job right now to try to, protect the associations. And I'm gonna mention something. This is relative to attorneys, and I think the attorneys, and not because Peter's a friend, but I think attorneys do a great job of advising you and advising associations, particularly the ones that know the business. But one of the things that you ought to always remember is it's the attorney's job to think of all of the possible things that could go wrong. and
they're risk averse.
Yes. They're not business people. And like I said, so if I'm an attorney and I see this liability, my first reaction is, let's get rid of it. We're not going to have this. Well, from a practical standpoint, if I'm a homeowner there and you're cutting off booze, I'm going to be really kind of ticked. So,
you're right.
there's a risk reward type of scenario that attorneys don't necessarily go through, but homeowners do. So that's all. I think it's just something that needs to be discussed. I don't blame the attorney. They're doing their job. Their job is to identify risk, plug the hole, and they've
Well,
done that.
I think the shock has been the suddenness of the action. I mean, this is 2 days ago, and it appeared out of the sky. It just, boom, happened.
Yeah.
And that was at the time that events were taking place and people were doing things. This is high season.
Yeah, I know. Yeah.
So the shock has had an impact on
Good.
a great many of the members of the association.
Go down to Century Village and tell them that down there. That attorney won't be around long.
I'm telling you, I understand that.
Yeah.
That's why I'm calling.
Yeah, well, no, it's a good question. That's and you know that this is creeping in more and more. So it's interesting.
Thank you very much.
Yeah, thank you, Stanley, and keep us informed. Let us know how it went.
I will.
Okay.
Thank you.
Thanks.
Thank you, Stanley.
It's an interesting. It is an interesting situation, Peter. You know, it's and again a good opportunity to kind of mention what you mentioned about the attorneys is, you know, that is your job, is to kind of make sure that this stuff doesn't happen. And it's the association's job to evaluate what kind of risks they're willing to accept, you know? And maybe the board just decided none, and that's, you know, but at least on something like this is one where I think the members, you know, need to have a say, in it. But the whole thing with this is I do see these things, you know, it's, you know, we're looking at a couple different areas that associations are exposed right now, or potentially exposed because people are going after them. You know, they have insurance. You know, associations have insurance. They have a lot of liability insurance, so they are an easy target, and you know, probably one of the first targets. One of the things that I think that we didn't mention in this thing, and I'll just throw it out there, is that in the state of Florida, if you're potentially a party to a lawsuit, in other words, you could be sued. So let's say the association there was an event that occurred on association property, and so now that drags the association in potentially. The attorney, even before, you know, really even before a lawsuit, even before you've been named, they have a right to know what your insurance coverage is. And it's the most ludicrous law I've ever seen in my life, but it basically allows the attorney to cherry pick who they want to go after. So on a case where normally they'd look at the two parties and they'd say, well, there's no money that can pay here. These people are broke, and you know, they got PIP, and you know, there's nothing here. And then all of a sudden they find out that the person was at a party at their HOA, and they immediately get the insurance policy, say, well, how much insurance is here? And they're not looking to, you know, most of the time they're looking to settle. As soon as they drag the association in, the insurance company says, we're not going to litigate this. And they offer them blood money to go away. And that's happening a lot in this area and in the area of employment cases, employment law. And again, another area where associations are wide open to lawsuit. You know, the situations of a lot of associations have people who volunteer to help around the community, and or maybe they're working part-time as a handyman or handywoman, or you know, maybe they're taking care of some of the bookkeeping activities or whatever. So, you know, next thing you know, those people are, you know, some attorneys making a claim that those people were employees to start with, that they were, you know, not paid overtime, that they, you know, they have all kinds of trouble damages that are out there, and they're easy lawsuits. So just be aware of that. If you're on a board and you're thinking about that, be aware of how that works, and and what's going on with it. Peter, let me give the phone number again, 220-9788. Of course, that's area code 772. 220-9788 is the number in the studio. If you've got a question and want to talk about this subject or any other subject that maybe something that's come up that you've got an issue with, we'd be happy to address it. Stanley's question was a good one, and hopefully it helped out some other people, because I know his association isn't the only one that's probably struggling with that and going through it. But it's funny, Peter. We've talked in the past about how sometimes people don't really know, unless you look at documents, you really don't know what kind of an association you are, whether you're a condo, an HOA, or whatever, especially in the condo arena, you could be that, and you may not be a high rise or whatever. So I was had a situation come up the other day, which was interesting, and an association, a master association that's been around for a long, long time. But in reading the documents, it was interesting. They had always thought that they were a condo association, but in reading the documents, they were a homeowners association, because even though they had a number of condos that they were the master for, there actually was a designated portion of the community that was never never finally developed. That was is an HOA. So they had one HOA in the whole thing, and the rest were all condos. And so it was kind of weird, because people couldn't figure out why, historically people had done, the way things were working. It didn't seem to make sense under and in fact, it really didn't. It really was not working the way it should have been done, because over the years, somebody thought it was one type of an association instead of another. Can you, and maybe you can talk about that a little bit in terms of what determines, in general, from a document standpoint, what's the difference between an HOA and a condo, and if you have a master association, what makes it governed by 718 and what makes it governed by?
Well, the master association situation may be changing because of recent case law, which is a little complicated, but generally speaking, a condominium is a creature of statute. So ordinarily, to have a condominium, you have a declaration of condominium, which basically subdivides the property into units and common elements. The common elements are owned by the owners and shares, not owned by the association. And you have declared condominium units under Chapter 718, which is the Florida Condominium Act. And although condominiums typically are when you have vertically stacked units, because you can't have you can't own airspace. Well, I mean, some people can argue you can own it through some more creative means, but generally speaking, you can't own the airspace without it being a condominium, because that is the statutory method allowing the developer, in essence, to create airspace as a fee simple unit that someone owns. And up until the early 60s, that's why you had co-ops, because there was no way to deed airspace. And then the Condominium Act came around in Florida and in other states, which enabled developers to create this type of property ownership. A homeowner association is where you have a declaration of covenants, which is recorded against property, that it doesn't create units per se like it does with a condominium, but the lots, you own the land, you own the dirt, you own your home on the dirt, and then you have common area, which is conveyed to the association. In a homeowner association, it's the more traditional, where you own, you actually own the parcel of land and the improvement or the home on that land. With a master association situation, the way the Condominium Act defines association is that in addition to a community where you have a declaration of condominium that creates it, it also includes in the definition of a condominium association any community where even if you don't have a declaration of condominium, but all the members of the association are condominium unit owners. The association operates property that all those unit owners have a right of use to, and all those owners also have a right to elect, or the representative of those owners have the right to elect the board of that association, and it's 100% unit owners. So that's what we sometimes call a statutory association, condominium association, because even though it wasn't created through a declaration of condominium, it's probably it might be some kind of master association that has condominium sub-associations under it. But if they're all condominium unit owners, then it fits within the statutory definition of under 718. Mm-hmm. So that's kind of in a nutshell how it works between the two associations, or the two types of property ownership.
Yeah, I know. Years ago, it used to be that when a developer was developing a piece of property, they would create phases, and even if they were going to have, ultimately they would leave one phase as an HOA, so that the master association wouldn't be under 718; it'd be under 720. So, and I guess that still would be the case today, then, right? But if that HOA parcel, that say the townhouse parcel, that's an HOA never gets built, then does that master ultimately then become a condo association, or is it?
Yeah. So what? So you have undeveloped property,
right? Mm-hmm.
And it's part of the master, though?
Yeah, it could still be developed, but it's undeveloped at this point.
I would say that's probably not going to be a condominium association.
Yeah, that's what I would
think. Because you're going to have, that would either be 720 or possibly even 617. Okay, yeah. It might not fall within 720 either, if you don't have, at least. So that one's somewhat of a hybrid. Mm-hmm. That would depend.
And then the other thing I was going to we got a caller coming in, so we'll take a little hold on here. I'll let Peter get back, and then we'll go over that question in a minute. But the other thing I wanted to get into with Peter and talk to the other thing I wanted to get in with Peter and talk to him about here in a second is the whole concept of rec leases and rec associations. But right now we got a caller, and we'll take that caller. Roberta, go ahead.
Good morning.
Morning. Thanks for calling.
My question is about our annual election to the board of directors. And we recently had our deadline for candidates to submit their eligibility statement of intent to run, I guess you call it. And after that time, in past years, you've always been given, or it's available at our office, I should say, a list of all the candidates so that everybody knows, here's the deadline has passed, here's the people that are running. And this year, we've been told as homeowners that we are not allowed to see that information, even though the deadline has passed for those candidates. Don't we have a right to know who's running before the ballots actually arrive in the mail?
Are you in a condo association or HOA?
Yes, a condo association.
Okay, and is your election going to be contested? In other words, are there more candidates than positions, or are they?
Well, see, I'm assuming that there are, but since none of us who live here are allowed to see that list, we don't know that that's the case. Do you see what I'm saying? I mean, if in the past our board secretary always just basically had the list at the front desk, these are the candidates, because it's several weeks down the road before the mail ballots actually arrive. And if we're not making that list available, then it's kind of like, well, what's the point of the deadline? Because then somebody could show up at the board secretary's unit, 3 days later and say, oh, I didn't get around to getting mine in. Here it is.
Well, no, I mean, once the deadline passes, which is the 40th day before the election, they're not permitted to accept any more nominations if you're a condominium association. I guess you could argue you don't know whether someone slipped theirs in later or not, but technically they're not supposed to. Now, I would argue that the names that have submitted, I guess, are part of the official records, and if someone makes an official record request, then to see, assuming that it's in writing somewhere, they can see the notice of intents, which are part of the official records. Somebody may argue they're not official records until the election has occurred. I guess that is a possible argument. But any kind of written record of the association is an official record subject to inspection. Again, there might be an argument that they don't become official records until the elections actually occurred, sort of like proxies, which really don't become official records until the meeting for which they've submitted.
And if there is if it's a contested election, in other words, if you actually are going to have an election because there are more candidates than positions,
I'm quite sure there are.
Well,
yeah.
In that case, they have to mail it out. In fact,
Well, no, you'll know. But
I know that.
No, but she wants to know. She wants to know before they do the mailing.
We've been around for
wants to know
decades,
now.
and our previous board secretary always basically posted a list because it's several weeks before we will actually receive their mail-in ballots.
They're not.
Our ballots in the mail.
Okay. Well, they aren't required to post a list. Okay. And they aren't required to respond to a verbal inquiry about who submitted their name. They may be required, like I said, if you send a written request that you want to inspect the intents. Again, they could potentially say they're not official records because the election hasn't occurred yet. But
well, and Peter, does the candidate have the ability to change that form up to the 40th day? In other words, let's say I'm a candidate and I submit that form that the association now has to send out no matter what, What,
the information sheet?
Yeah, the information sheet. And
the information sheet has to be in by the that has to be in by the 35th day. That's something else.
Okay, so what I'm saying is, if I on that, I wouldn't want to give that out yet until I knew it was finalized, right? I mean, the person could, these information sheets I hate because the law says the association has to, send it out verbatim.
Correct.
And then we get some things that happen there that get nasty sometimes, and so sometimes it's good if there isn't that those don't ever go out. But what I'm getting at is that information might not be available prior to because the person could amend it or change it.
Sure,
potentially.
That's not what
True,
I'm asking
but she's
about.
not asking for that. She's not asking
I know.
for that. She just wants to know who has submitted their names.
Okay.
Okay. And again, they don't have to post that. They don't have to tell you. The only way you could potentially force it is to put in an official records request saying, I want to inspect the intents that have been submitted.
Yeah.
That's the only way to potentially force them.
I guess then the question is, how is one able to enforce a deadline? I mean, there's a lot of dissension on our board and between different members of the board. And if one board member doesn't necessarily know that the board secretary is fulfilling those responsibilities and duties in a legal way, how is that supposed to be determined if that list isn't made available once the deadline has passed?
Well, I say it may be made available upon a written request. Is there a potential for shenanigans? Yes. Good point. If the secretary, I'm just making this up now, but let's say it's that the 40th day has passed and somebody wants to submit their name, okay, and this is a friend of the secretary's, just for the sake of argument, and they're in cahoots, so they both swear, oh yeah, that was turned in, by the 40th day. How do you prove it wasn't? Very difficult, to be honest with you. The person who submits it is supposed to get, if they hand deliver it, they are required to get a receipt from the association about the date that it was submitted. Or if you send it by certified mail, obviously there is a certified mail receipt. If you just mail it in by regular mail, there is no requirement that the person receives a receipt. So you would have to somehow prove, that it was, that this person's intent came in too late.
Yeah.
Okay. Well, it's not easy. I'm not claiming that. What was confusing to members of our community was that in past years, that list has always been made available, frankly, like an hour after that deadline passed, which was noon on a certain day, 40 days before. But
I don't know why they changed.
I
don't know why they changed their policy. I don't know why they changed their policy.
Obvious written change, just that the secretary decided not to, and that's okay. Is what you're saying?
Assuming the board goes along with it, yes. Again, there is no legal requirement to post those names or to voluntarily release them until they send out the second notice when it has the ballot with all the names listed.
No, but Roberta, you mentioned, and it's a good point. And it's something that the association should have procedures for. You've got a valid point there. If somebody delivers it by hand, should it be enough that just one person, or is it just the secretary, or is it just the president? Is that enough, or should it require that two people timestamp it? Should you have some documentation that somebody else saw that and that it was timely filed? The old slipping it under the door at midnight type concept really shouldn't be allowed. I'm
not claiming that that's happened.
No, I know you're not, but I'm just talking in general.
People in our neighborhood walked to our office, asked to see a list, and was told that we had no right to do that.
No,
so there was a certain amount of confusion about that.
I know you're not saying that, but what I'm saying is for associations out there, your question brings up a really good point where an association really should address what kind of procedures they're going to have for this. Is it going to be good enough? Because to me, if all it takes is just the secretary to say, yeah, I got it on time, I think maybe, that's going to be subject to challenge. If I go to court, I don't think a judge is going to, say he said, she said, might not work. And so, especially if there is some circumstances there. Same thing with the stuff that comes in by the mail. There should be a procedure to keep the envelope that shows the postmark. So you've got at least something that shows a postmark prior to the deadline, and somebody should have initialed that off as to when they got it.
Like I said, right now the only thing the law requires is that if someone hand delivers it, they're entitled to a receipt.
But that receipt could be signed by a secretary or somebody like the secretary or somebody like that.
Yeah.
And what I'm saying is Well,
yeah. See, when you were talking about sliding it under somebody's door, so the board secretary could write a receipt that says he got it on such and such a day at such and such a time. I think our simple solution to that was in the past when we posted a list of these are the candidates an hour after the deadline passed, then everybody knew that everything was on the up and up.
Yeah.
Because these were the people.
And that might be a good procedure for the board to adopt instead of some of these others.
It's not a legal requirement.
Not a legal requirement. But
no.
Okay.
Now what
you can write to your legislature and make that recommendation.
What kind of restriction can you have in terms of Peter? What kind of restriction can you legally have relative to the submission of a candidacy form? Can you slip it under the door at midnight?
Well, actually, there's a case on that where someone slipped it under the door at midnight, and that was held to be invalid because they couldn't prove that they had got it there under the door at midnight. They couldn't prove it. Okay. So there's two cases like that. One is a slip under the door, and one is the person gave it to the security guard, supposedly, at 11:50 the night before, and that one was held to be invalid because he also couldn't prove. So it's really the burden is on the candidate to either hand deliver it or do it by certified mail to have that written receipt. Okay, if they do it by regular mail or some other method where there's no proof of delivery, the law will go against the owner submitting it and in favor of the association who says that they never got it on time. So again, the burden is on the owner to do it by a method where they get a written receipt.
Now, can an association adopt reasonable rules? Like, for example,
you couldn't adopt the rule saying that we aren't going to accept them by mail. I don't think.
No. But could you have a rule that says that anybody who's hand delivering a candidacy notification has to do it during normal office hours or something like that?
Yes.
Okay. So you can have some things there that would allow you to, but you couldn't do but you couldn't do something like I guess the association could adopt it, but you couldn't force. Can you force if the board votes for it? Can you force them to identify who the candidates are within a certain period of time after the deadline? No. So you can't do that. But you could.
Who could the owners force the association to do that?
Well, the owners or the board. If the board decided they wanted to do that, can they?
The board could do it as a policy, I guess, if they wanted as a policy,
okay.
post the names, but
they're
not required to.
Right. Okay. All right.
Okay,
Well,
thank you.
Mm-hmm. Thanks, Roberta. Good question.
Thanks, Roberta.
Yeah, that's a good question. I these elections are, it gets kind of.
No, they get sticky. They get a little hairy because, especially when no one trusts anyone.
Yeah.
Sometimes.
And even Roberta wasn't saying necessarily that was the case, but she was just asking the question. The policy, the rules had changed.
No, I understand.
Changed, and that's kind of. And I do think that associations need to consider this type of stuff. I mean, they probably need to contact their attorney, make sure make sure that they're within the law on this stuff. But I do think that the association needs to have some sort of internal control, some sort of procedure to make sure that they're protected in that situation. That receipts can't be backdated, or that people can't send it one place. And for example, even the mail situation, the association should have a policy to keep those envelopes, because just because the mail doesn't require a receipt, you still may have to prove that the person mailed it on time or sent it on. How do you know? You get something that comes in a week later and that person claims, well, I mailed it. Well, if you don't have the envelope, or you don't have.
Well, I just mentioned before that the burden is going to be on the person submitting it.
Yeah.
Okay. That they submitted it timely. Because regular mail sometimes gets there in a day and sometimes gets there in 5 days, right?
Yeah.
Depending on whatever. So that's why even in the statute, even in the rules, it encourages people who are submitting it to do it either by, as I mentioned with Roberta, the Florida Administrative Code encourages people to hand deliver it so they get a receipt, which they're entitled to, or by certified mail, where they get a receipt, or some other method where there is a proof of receipt. Mm-hmm. You can do a FedEx. There are certain ways to do FedEx where you require the receipt to be signed.
Right.
Something where there's an action. If you just do it by regular mail, and there's dispute about when did it arrive, most likely the owner is going to lose because they cannot prove when that arrived at the association office.
Now, in this scenario that we're talking about, mail, that type of thing, it's not based on when it's postmarked. It's based on when you receive it, correct?
Yep.
So that's confusing for people, because a lot of times, like with the IRS, it's when you postmark it. But
no, for this, it has to be received no later than 40 days before the meeting.
Yep. Okay. Well, those were good questions today. I appreciate both of those questions. It's that time of the year, and both of those things are important. And hopefully, we were able to stimulate some discussion among other people out there who may want to change what they're doing or do something a little bit different on their situation. Peter, we appreciate your knowledge, and I know all of the listeners appreciate your knowledge and input on these things. And you are good at coming up with not only the legal issues, but also the practical stuff that goes with it, and I appreciate that. And I know our listeners do. And we appreciate you guys joining us here every Monday from 9 to 10 o'clock on Condo Solutions right here on WSTU Digital 1450. We are Martin County's Heritage Station.